In the last couple of weeks, there's been a giant thermonuclear bombshell dropped on the jiu-jitsu community, and it's the story of a $46 million lawsuit or the payout on a lawsuit that came from a horrific jiu-jitsu injury that was back in 2018. Basically, a gentleman was sparring. He was a white belt, apparently had some wrestling background, sparring with his instructor. His instructor did a style of rolling backtake, which I first saw, I want to say, in the early 90s. We called it then the Leo Viera Backtake. And the poor guy had his neck broken. So there's a couple cervical vertebra damage. He's never going to be the same. He has recovered the ability to walk, but the lawsuit went forward. And with Rener Gracie testifying on one side and Clark Gracie testifying on the other, recently the news came down that the injured person was awarded $46 million. So this has created a tremendous amount of anxiety in the jiu-jitsu community for people who are teaching, people who are training, people who are teaching but aren't the main instructor. And like, what does this mean for me? I know several people are like, that's it, I'm not teaching anymore. I don't want to lose my house. I don't want to lose my pension. I don't want my wages garnished. I don't make enough money from jiu-jitsu to make this risk worth it. So to talk about this and to try and ultimately come up with a sense of what this means for the community, and more importantly, what you can do to maybe protect yourself, I've gathered in the two people that I know and like very much. Dan Lukeheart, who teaches jiu-jitsu in California, is a voice of reason, very rational human being, very decent human being. And he's also been following this trial very, very carefully. And I've also brought in Alex Kask, who's a lawyer and is a longtime martial artist, was my main training partner during COVID. We would do rapid tests. Presumably we would both end up negative, and we'd train together, and it really helped certainly me from going insane. But in addition to a martial artist, he's also worked a lot in the law, and especially around like injury cases. He's been for the last couple of days trying to brush up on what happened here. So have I said anything that's wrong so far?
Not at all. Not at all. So thanks for having me on.
Well, before we get started, and before people think that we are their special internet lawyers, Alex, we should probably give some disclaimers here. You're the lawyer. What should people do and not do when they're listening to this podcast?
I think one of the things that you want to keep in mind here is that, what we're going to be talking about here is information which is of a general nature. And I want to be clear that this doesn't constitute legal or professional advice of any sort. And also listening to a podcast doesn't create a lawyer-client relationship. I think that's kind of self-evident, but, it needs to be said. So more importantly, if you do have specific legal issues for which you need to seek advice, your best bet is to consult a lawyer in your jurisdiction regarding those specific questions.
Yeah, 100%. I mean, we're not giving legal advice. We're not, I mean, if you're getting legal advice from a podcast, then you're probably also getting your health information from Joe Rogan, and you're ignoring what your doctor's saying. There may not be any helping you, but we got to say it. Listen to your doctor and listen to your lawyer, and totally ignore us. But maybe we will help create some questions that you can then ask your lawyer and sound a little bit more intelligent. Obviously, in the context of a podcast, we can't be complete. We can't be 100% accurate because we don't know your situation. And, there's just not enough information that we have about your specific situation to give you definitive legal advice. That should be obvious, but it's not always obvious.
One other thing that's probably important for the listeners to also understand here is that in preparation for this podcast, we've researched this using the best materials available to us. So we've accessed the materials that are filed over at the San Diego County Court, Superior Court registry. We have submissions and, some of the filings that are there, which means that, unfortunately, we don't have the complete record necessarily. We don't actually have, for example, all of the transcripts of the proceedings or the depositions and that sort of thing. What we do have, though, are submissions that were made by the counsel that reference that same evidence. So I'm assuming that they weren't being inaccurate in what was set out in the submissions, but we can draw inferences, therefore, I think, about what the actual evidence was based on that. So, our comments, therefore, need to be considered from the perspective that, we don't have the benefit necessarily of the complete record. And one other thing I should probably mention here is, each of us comes to this, of course, just with our own personal opinions on things. Please keep in mind that, therefore, these are our views and not necessarily those of anybody else.
On my end of things, is that there's like two facets for me on this case. One is exactly what you said, which is what are the implications for the greater martial art as a whole, as an academy owner? But also for me, like a dual element for me is like almost a battle of ideas with what jiu-jitsu is, what it should be, or what it should become, which I feel was interjected into this case. So for me, it's like double faceted in that way.
I think I'm on the same page as you, and I definitely want to get to that. But Dan, could you maybe take us through, I mean, we've all seen the injury, but maybe take us through what's happened so far in more detail, from the injury to the testimony on both sides. I just gave kind of the 10,000 foot overview at the beginning.
So, like, I became aware of the case more when everybody else became aware of the case. This actually was leaked to me years ago, where I just completely dismissed it. Somebody told me that there was some lawsuit, somebody was injured, and I was just like, I just deleted it from my brain. But looking back on it, I realized that they were trying to tell me this, and I just didn't see the severity of it. They didn't tell me it was paralyzed. They just said some injury happened. But you know what? Injuries happen at a lot of different places. So I haven't really been following the case. I was just, as the information came out to the public, which is the way that most of us consumed it. I think the first one that kind of hit the media was the Fox News report. I think Rener shared that as well. And my first thing is like, what move was it that what was the injuring move in this? And then the description, which was provided not by Rener in the original thing that I had read, was so bizarre to me, which is some of the quotes that we are now all aware of, which is like the goal of jiu-jitsu should be to safely return him to his side. These were the types of quotes that I was reading. And I'm thinking, what on earth are these lawyers? You can kind of tell maybe they don't know jiu-jitsu the way that they're describing this. And to be honest with you, in my brain at that part, I thought there's only one person that I know in jiu-jitsu that could be describing it in this way, and that would be Rener. That was like a inside the brain guess that I made. And then just a few hours later, Rener made his post about how he was involved in the case. And to me, I already kind of knew the types of things that he was going to say, because I was the Kool-Aid drinker. I started out with Rener. Rener was my first coach, not for very long, for only a couple of months before I switched. But I was like the Gracie Kool-Aid drinker. If you were to like picture somebody that's like talking about how Elio invented leverage and all the stuff that goes along with that, that was me. And I knew that how he would represent jiu-jitsu, because as I understand it, is that you need to kind of show on a legal level that what the instructor did was outside of the norms of jiu-jitsu. And I knew from just that moment that Rener would be representing what the norms of jiu-jitsu were. And the more I learned, and the more things that were at first leaked to me, and then I got the documents through some lawyers who pulled the case documents for me, it was like basically in line with what I had suspected. So yeah, that's kind of like my overview of how I've got involved in this, as well as kind of a little bit my personal motivation in the case.
I think it's important to point out that the school, Del Mar Jiu-Jitsu, did have insurance. So essentially, it's a guy who's injured and whose quality of life has changed for the rest of his life, suing the school and the insurance company paying out to cover him. And I don't think any of us are contesting that this guy should have gotten money. I mean, especially, I'll let my Canadian flag fly. Healthcare in the United States is incredibly expensive compared to socialized medicine that's in Canada and almost every other industrialized country. So this guy's going to need a ton of money going forward. So we're not, would I trade my banged up but still healthy neck for $46 million and partial paralysis? Absolutely not. We're not saying that this guy didn't deserve money. I don't think. Would we agree on that?
Yeah, Alex, if you wanted to,
Yeah, I mean, from what I've read in terms of the submissions that were made to the court that described the injuries that this fellow went through, I mean, this is a really tragic situation. And, these are life-altering injuries that this fellow had suffered. It was a C5 fracture that, required a titanium cage, fusion of 3 cervical vertebrae, C4, 5, and 6. It was a stenting of the left vertebral artery that was required. He was an incomplete tetraplegic initially, so I mean, these are really horrific injuries. He suffered respiratory failure. They needed an NG tube due to dysphagia. And, because of neurogenic bladder and whatnot, initially he required fully catheterization, among other things. So, I mean, we're talking about a very, really terrible set of injuries that this fellow suffered. So, I mean, I'd like to just start by, putting into context that, this is the experience this fellow had. So, where the challenge arises, of course, when you're dealing with a civil lawsuit is that the idea in tort law, as we describe it, so when you're dealing with wrongdoing and, doing a fault-based analysis, what the common law tries to do, whether it's in Canada, the United States, England, Australia, wherever, is that they try to make the tort victim whole. So what you have to do is say, well, you had a person that was thriving and having a certain lifestyle. That's been diminished. And, in some cases, it's diminished only in small ways. They had a bit of whiplash and, they've had a 5% diminishment of their total life experience. As you can imagine, when you've had something like this is a very different story. So you have to try to appreciate, what this fellow went through to appreciate where they get to the number that we're talking about here. And I can actually just break down the number a little bit. This might give a little bit of context, which I think hasn't really been covered up until now, because we were able to find a copy of the actual jury's verdict on this. And out of the 46 million that was awarded, so the total award was actually $46,475,112.30. Out of that 46 million, 36 million of that was for past and future pain and suffering. So the rest was for loss of income and for past and future medical expenses. So it was the medical expenses that actually made up 9.8 million of that award. So if you look at it that way, what the jury was saying was, okay, well, he's going to require quite a bit of care, and that's nearly $10 million worth of care. And his ability to earn income that otherwise, would have been realistically within the possibility of him doing, well, that has a valuation of about $637,000. So anyway, the point is that in the judgment, they're trying to say, well, we can't put you back and not have you have this horrific experience. Well, what we can do is an ersatz way of trying to replace this is to say, well, we're going to give you money in lieu of whatever all those experiences in life might have otherwise been, and this is what we value it at.
So, kind of my take on this is that I have no problem with him, even with my current opinions on the case. I have no problem with him getting paid out. But if we actually examine it, the question that was asked the jury, which was one, and if they answered yes to this basic one-line question, then they went to the second question. It was basically 2 questions that were asked to the jury. And I don't want to mess this up because what Rener posted was, not that it matters. It doesn't matter that Rener kind of didn't get it right, but this is the question that was posed to the jury. Did Sinistro, I'm substituting his name, did Sinistro unreasonably increase the risk to Jack Greener over and above those inherent in Brazilian Jiu-Jitsu sparring? So this is where I kind of have my, I could totally see a legitimate argument for everything that took place is inherent in Jiu-Jitsu sparring. This move, as you mentioned, Stefan, you learned in the 1990s. This technique, which he labeled the forward flip backtake, that's a little bit frustrating to me, because if he calls it by what the vast majority of people call the name, then it almost gives credence that it's a commonly performed move. Oh, look at this multiple-time champion. He performs it. You can go on the recent Buchecha trailer for his documentary that just came out on Flow Grappling. Buchecha's doing it. You have many generations, many decades of people doing this, all with their own variations. And you need to kind of remove the name to make it sound a little bit more fantastical. And if you call it a forward flip, that word flip, who calls this the forward flip backtake? As somebody that's been doing jiu-jitsu for 3 decades, I realize that there is no standard nomenclature. But if we were
calling it the dynamic reckless neck breaker, Your Honor.
Yeah, exactly. There was definitely this, and I know that they kind of carefully selected the name for what they were going to call this technique. I would have made an argument that we shouldn't be calling it this at all, because it's not what it's called in the Brazilian Jiu-Jitsu community. But this isn't really my point. My point is, without the benefit of hindsight, nobody with our experience level, I wouldn't imagine, would have seen somebody performing this, a black belt to white belt, it doesn't matter, and be like, oh my gosh, that is completely negligent. Anybody that says that, and there are people that with legitimate backgrounds and length of time training, there are people that feel that, and I need to acknowledge that. But I honestly think that that's just hindsight 2020, because there's a couple of different subtle arguments to be made here. One is that he argued that the move itself was known to be the most dangerous backtake of all of jiu-jitsu, which is completely and utterly false. Every move in jiu-jitsu contains within it the possibility to do harm. And basically within the context of that, there are definitely different ratios involved. But the reality is that this move is practiced thousands and thousands of times per year on a safe way, and it does not have that reputation. For example, heel hooks do. I know heel hooks less severe. You're talking about a knee and not a neck, but heel hooks definitely have a stigma in jiu-jitsu. Can openers definitely have a stigma in jiu-jitsu. If you were to do a twister, there is a pre-existing stigma in jiu-jitsu. There is 0 organizations that ban this technique. Not even Rener's own organization. You're probably been in jiu-jitsu long enough. Do you remember when Rener created his own organization in the early 2000s? You might not. And said that he was going to revolutionize sport jiu-jitsu. It was like the Gracie Jiu-Jitsu International Federation, I think it was. His organization didn't even ban it. So the fact that you can argue that just this technique, independent of the specific way that he did it, just talking about the Leo Viera Backtake, is somehow negligent to do on anybody of any belt level, to me is completely crazy. And then there's the second fact of this argument, which is a little bit more subtle. I think he understood that argument is a little weaker, because some nerd like me can dig up a 30-minute highlight, assemble, pay me money, I'll find 30 minutes of Leo Viera backtakes in competition, and I'm going to, Your Honor or jury, here is a 30-minute video of this, and I can find it at all belt levels. I have seen it at all belt levels in competition. So I think what he needed to do was he needed to say that this specific application was negligent. And at first, you read in what we are in the community referring to as his deposition, but apparently it's not his deposition. Whatever, it's his words in court. As far as jiu-jitsu speak, we were talking about this a little bit before, Alex can kind of fix the nomenclature on this. But he wasn't quite aware, he said, of the arm being trapped. Now, let me get into the specifics of this. I think that on a legal sense, he needed to make the argument that this manner in which he did it was somehow unique and therefore outside of the standard of practice in jiu-jitsu. And it's so frustrating to me that Rener can successfully apply this argument to people in the jiu-jitsu community. And Rener, by the way, is somebody who tailors what he says for his particular audience, which is exactly what he did when he came out and said, I was involved in this case. He got spiked on his neck, joined the Gracie Academy, we're safe. Or excuse me, Gracie University, we're safe. Still in a couple decades ago. Is that he was in the wrong frame of mind. And he even said that I had just got done talking to a bunch of lawyers and all that, and I was in that frame of mind. So it was frustrating to me that he was able to sell this argument that this technique was negligent the way that he applied it. And he had specific focus on the arm trap. Let me tell you something about this arm trap. His argument was twofold, yet on a technical level related to this arm trap. One is that you can't get high enough to put the shoulder behind the neck to force him to roll. And two, it takes away his partner's ability to base in the turtle position. Let me address that second argument first, which is it doesn't allow him to put his hands out to base in the turtle position. Does Rener not freaking know jiu-jitsu? You do not play the turtle position like this. You play the turtle position with your arms on the mat and your head either one way or the other. Here's what I want you to do. You're at home, you're watching me on YouTube or whatever. I want you to go to Prit, P-R-I-I-T. And Prit is the world's expert at the turtle position. He is the modern incarnation of Eduardo Tellez. I want you to go to his Turtle 2.0 instructional on it, and he just talks about the position of it. Tell me where he puts his hands out here. The arms posting is completely irrelevant to the way that you play turtle. Now, because I'm not out to misrepresent the way that people play turtle position, I realize that there's a lot of different ways that you can play turtle. But to say that he took away his arm so he's not able to base somehow makes it negligent is crazy. It actually makes it easier to roll, but I'm going to digress on that. So, second is that Leo does it with a double underhooks position with an S grip and that jumps over the top. There is literally no difference in having basically a low seatbelt. Your arms are in the same altitude, if you will, as far as the chest, where you're clamping, whether it's an arm or not. You can easily jump all the way over the top and apply your shoulder against his neck and get him to fall forwards. Rener's two arguments are completely bunk on the technical elements of this. And that's because he does not understand this position. What you guys need to understand is Rener is very good at looking and recognizing at things, but he has certain misunderstandings of techniques. How do I know? Because I used to be that person. I am the analyzer. I've been analyzing for 10 years. If there's anything that you know me for, it's being the guy that analyzes a bunch of techniques. And I can accurately describe, at least in the past, and certain movements even today, I can accurately describe them with proper and full understanding of the movement itself. And I'm telling you, that's what's happening here, because nobody characterizes this position in this way. The fact that it's over the arm invites him to roll easier. The real reason that he got injured is he tried the Leo Viera Backtake and it went bad. And it went bad because the guy posted on his forehead because he was using it as a third post. Right as he went to roll, he, instead of the way his head was kind of outstretched. So your forehead is on the ground. So it's not even like you go over the top and kink your neck a little bit. And then as the roll was completed, his head broke towards the wrong side. So if you want to argue that trying the Leo Viera Backtake, a standard movement, was negligent or against the risks inherent in a jiu-jitsu practice, I take issue with that. Second is that his specific application of the movement was not negligent in the slightest. It's just the move. The move has in it the possibility for neck injury, as do all moves that require a forwards or a backwards roll. Star sweep, stack out of the armbar, stack pass, they all require the person receiving the movement to essentially do a backwards roll. Double underhooks, dump them over really aggressively. And that was a part of the more meat of Rener's argument. I have problems with the way that he represented jiu-jitsu in a number of different ways, which I hope that we don't get sidetracked and we don't end up talking about. But that was really the meat of the technical argument. Nobody saw it until it was colored. I saw it the second it happened, and I dismissed it as irrelevant because it's not relevant. Here, you're at home right now. You don't believe me. You're not sold on my argument. I want you to type in Leo Viera Backtake on YouTube, and I want you to go in any of the videos. There's probably 6 easy examples of Leo doing it in competition. And I want you to look at how the person is defending. He's defending hooks. He's not even using his arm. I don't even think you can find a single example where the guy doesn't have his arm self-immobilized. Maybe if, Stefan, if you're doing this later, maybe you can go and check me on this. Fact check me. And this isn't even like I've studied the video a lot. I just know that there's how you're supposed to defend this position. Nobody's going to go, oh, please put in hooks. Let me put my hands up here so I can base it in case he rolls. That's not the way they do it. And by trying to defend hooks, you're forced to post on your head. So a little bit part of this, I want to deal with the legitimate points of Rener's argument. I forgot where I was going there. Sorry, I got sidetracked as to what I was doing, because I want to address more like the meat of the argument, which is you have to kind of segregate it out from, is the Leo Viera Backtake dangerous? And some of the commentary in jiu-jitsu is legitimately, I'm a little uneasy with this technique. Personally, I'm a little uneasy with this technique. Ironically, when 2 weeks approximately before this came out, I was teaching some stuff from the turtle position. And at the end of the class, I wanted to show something extra, just a little bonus. And I was like, oh, let me show him the Leo Viera Backtake. And I didn't even show it. I was like, Noah, do you know the Leo Viera Backtake? Can you show it for the class just really quick, just so they can see it? Because I didn't feel comfortable doing the technique. This existed prior to the injury. However, it was not against the standard of practice within the jiu-jitsu community. And that's where Go ahead. I've been talking for a long time.
No.
Yeah.
I think we would all agree that there is such a thing as negligent moves. I mean, to pick a ridiculous example, if a white belt girl comes into my class, she's got a tight turtle, it's pissing me off. If I pick her up and power bomb her into the mat,
if you will, spike.
If I spike her or tombstone her into the mat, that's negligence. If I do a flying kanibasami on a day 1 white belt and I explode their knee, it's not as serious as a damaged spine, but that's probably negligence, right? Like that, they have no idea of what to receive. But I think a big part, if you read what we're calling the deposition, which is actually Rener's declaration, he makes a big point out of, yes, this is a move that might be used in, by advanced practitioners, but it's not something that a black belt should be doing to a new white belt until they've been properly taught this move and know how to receive it. So now you're put in a position where you have to teach the white belt every possible thing that you might do to them before you try it on them in sparring.
We know that's ludicrous. We know that is absolutely not the way that it ever could work without changing the inherent nature of the martial art. Now, Alex, I would have easily, and there was overtones of this in what I've read. You basically doing a forwards roll and a backwards roll is instructing them on how to properly receive a movement, which is going over your neck. And are you telling me in 3 years experience that they had never seen a forwards roll or a backwards roll? And certainly this competitor has. That's not out of the question. That's out of the question that they had not been instructed on a forwards roll or a backwards roll. These type of like avoid the neck things. It might not have been in that context of like, you need to do the forwards roll and the backwards roll to not have any sort of like damage on your spine. But it's like, you need to do this this is just how you move. This is how a lot of instructors do it, because it's not always through the lens of safety. And I want to just speak briefly about your other point, which is the black belt versus the white belt thing. The way that I roll with my students, I do not limit any sort of technique that I do. And I think what is important to a jury and what is important to us as jiu-jitsu practitioners is different. What's important to us is how much experience did this guy have? What the image that we all had was it was somebody on his first day because of it was represented by the plaintiff's lawyers in the material that we were reading. And that matters a whole lot to us because we know that legitimately Rener's statements of we need to be ready, ensure that they're ready to receive the technique or have the knowledge to receive the technique. But, beyond the first month, really, it's kind of like that super awkwardness is out of the student. They're still awkward, but you don't I only limit for the people their first week. Otherwise, I'm just rolling. And I think that's the way that most people do it.
So the thing that came up again and again in Henner's declaration are things like this. First, he establishes himself as a Gracie and his lineage.
Yeah, let's
and then
go
things like the Gracie family was instrumental in establishing the standards for the martial art and the sport. And then later, the industry custom is for beginners to take courses separate and apart from advanced practitioners. And then, did not use any of the traditional methods to take Mr. Greener's back. So it's establishing. It seems to me that he's trying to establish his approach, which is a distinct approach, as the standard in jiu-jitsu. Can we just pick Alex's brain as to how important is establishing a standard within a sport and a standard of behavior? And if I can get there first and I can say the standard of care or the standard of, I don't know, whitewater kayaking is to everyone to do it the way that I do it, that gives me immunity I'm assuming that gives me a certain degree of immunity, and it gives Dan's competing kayak school a certain degree of liability if he's not doing it the way that I'm doing it. Or am I wrong about that?
Can I just do one thing? Because I want to really, you said something there and it kind of skipped and I might have talked over it, is that the Gracie quote, the Gracie family was instrumental in establishing the standards for the martial art and the sport. And it's, as you said, I just want to highlight what you said, is that he's clearly saying that I am the law, to court Judge Dredd. He's trying to establish himself as that. So I just wanted to emphasize that for Alex in his response.
Yeah. So what you have to appreciate is that this claim is sounded in negligence. So with negligence theory in the common law, what you have to do is follow a simple formula. And that is that the burden of proof is left with the plaintiff. So the plaintiff must establish that there was simple negligence. And then I can read you through what the formula is for that. But the thing in California that's unique is that that's not enough to actually establish a claim against an instructor. In California, you actually have to establish that over and above the simple negligence, there was also reckless or intentional action by that instructor that led to the loss.
Can I interject really quick? There was a whole document where the plaintiff was making the allegation that Sinistro's actions were, quote, despicable. Is that a part of what you, and Henner's testimony was used to support? Henner did not say himself this, but his deposition, or whatever we're calling the deposition, was referenced in the despicable argument. Is that despicable? Does that have a legal kind of framework associated with it?
My best guess on that one would be that it probably relates to the claim for punitive damages. You might have recalled that there were some submissions in there where they were talking about evidence that they could have utilized in relation to claiming punitives over and above all the other damages that we're talking about here. So let me explain. So when we're talking about the award for the $46 million that we discussed at the start of the podcast, that's compensatory damages. So this is where the jury looked at what this person's experience was and said, to make them whole, we got to give this guy $46 million. However, that's not where damages necessarily end. There can be this other thing, which are the punitive damages. And you hear about this on the news quite a bit. What punitive damages are a way of awarding additional amounts against a tortfeasor. So, a wrongdoer, where you're saying that what this wrongdoer did was so despicable, so egregious, so, off the charts wrong, that they need to be punished for that conduct. So you might recall that there was the issue, for example, with Ford products. They had the vehicles that had the in the assembly behind the bumpers in the
The
70s.
gas tank that was
gas tank.
behind the bumpers and it ignited on fire. You're referring to this case. I'm familiar with this one.
They identified the problem, and they chose to pay out the wrongful death settlements rather than fix the problem. Well, it was during that litigation that they said, look, this is not okay. We need to punish these guys. Like, to simply compensate people is not going to fix the problem because these guys have a profit motive that's not okay. So we need to punish them over and above that. So that's where punitives fit in, is feeling that rule. So my best guess to answer your question would be that they were trying to seek that. I didn't see that there was any indication that the jury was swayed to find that because there was no word referencing punitive damages that I've seen so far. So anyway, that's one thing. So we've got the idea of compensation versus, punitive awards. But to go back to the question of negligence and recklessness. So the plaintiff, to establish the claim, has to prove on a balance of probabilities that there was simple negligence and, in California, reckless or intentional action. So what is simple negligence? This is where the standard of care comes in. What you have to do is figure out, as a matter of negligence, is what are the relationships between the various parties? Is this a situation where, for example, you have an instructor and a student? Or is this a situation where it's two competitors? Or, is it a situation where it's two guys in a bar? In each case, you've got to go down and say, well, what would a reasonable person do in the same circumstance? So what you're trying to say is that looking back with hindsight 2020, what would a reasonable person do that wasn't done here? Or what would they not do that was done here? So it's either a question of malfeasance or nonfeasance. And if they say that there was a standard, the standard wasn't met, it was breached, that breach, then if that is leads to approximate loss, so basically the wrongdoing leads to the injury in this case, then they can go to the other phase, the final phase, which is to quantify the loss. So in California, they have a situation of comparative negligence. So you can have things where they try to figure out, who's at fault, whether it's completely the plaintiff, whether it's completely the defendant, or some mix thereof. Under common law, that would have been a bar. But in California, you could actually have it where maybe the plaintiff's a little bit at fault, or even, you could have it where they're very, very, very much at fault. And then
what was the reason that this wasn't done? Because it was just like, guilty, here's all the money. Because it wasn't sliding scale. Because I think most of us might have been okay with like, all right, this is like 40% Sinistro's fault or something like this. But it was like all or nothing, at least the way that I was viewing it.
This is a finding of fact that the jury would have to reach. And I'm not exactly sure what led to the question of them getting to the final judgment where they were saying, no, well, we're satisfied that this guy was not at all contributorily negligent for whatever happened. So therefore it's 100% liability as against the defendants. So it's a little unclear how they got to that. For whatever reason, that was the finding. So 100% liability, and then you get the $46 million quantification. But where Rener Gracie fits in and where Clark Gracie fit in are that they both had to be talking about what is that standard of care. With the relationship in this case, what should an instructor be doing when dealing with a student of this ability? And there was a lot of questions about the capabilities physically of the plaintiff. And what they meant by that was, how experienced was this person? How athletic was this person? And there's these fundamental questions about, is a rolling back take an illegal move? Is a rolling back take an inherently dangerous move? Are there safer alternatives? These are all factors that get considered as part of the analysis. But ultimately, what they have to do is establish that there is a standard and that there was a breach of the standard. If you don't establish that, the case falls apart. So anyway, they've got, the two different Gracie experts who are saying, well, the standard either should have been this or should have been that. I didn't see enough about the evidence by Clark Gracie to be able to say what his commentary was in relation to standard of care, because the materials I saw didn't actually include his reports or depositions or anything like that. So all that I could see were the submissions that were filed with the court that referenced what his testimony was. So it would be interesting to know what, his opinion was with respect to, for example, standard of care and, what is the, is it, what does he have to say about a rolling back take, for example?
Can I get in one thing here? Is that in Henner's Instagram live with Tom, he had said he read, because he has a transcript of the trial. If I am upset enough by the reaction to this, I will drive down to San Diego and get it. But apparently you have to get it in person, and I'm not so eager to do that. But he read on the stand Clark being questioned, saying, "Do you teach the move like this?" And Clark was like, "No, I don't teach the move like this." And that's so frustrating that he would say, "Now, Clark, look, he said it, blah, blah, blah." Of course. Would you answer that you taught the move like that, Stefan? No, I wouldn't. With the arm trap, because Henner was focusing on, no, because jiu-jitsu is filled with endless variations. And of course the guy's going to say no. And then when he asks, "Do you have a beginning program?" He goes, "Yeah." So what? That doesn't mean that not having a beginning program is like Clark tanking the case or something like that. It's like the lawyer, they ask these questions and then they piece together some narrative based on the questions. And like Henner's doing that to us, saying that, "Oh, Clark said he doesn't even teach it this way. This is not normal." That kind of bugs me too. Because
there's 1,000 ways to teach it. Like, you might grab with 3 fingers inside and I'm grabbing with 4 fingers inside. And does that mean that if an accident happens to me, it's because I did it with 4 fingers inside? No.
And the arm here, I think the arm trap really cemented his case to a lot of jiu-jitsu practitioners, crazy enough to me as that is. And also to the jury, it's like saying, "Look, this is not the normal way to do it. You do it with a double underhook, or you do it with a seatbelt." And it's like, who's going to teach it over the arm? I look at that over the arm, even with the injury, and I was like, well, that's kind of interesting by Sinistro. To be honest with you, like, that's an interesting.
So what does this mean moving forward?
I picked up in video analysis. Go
ahead. What does this mean moving forward? Like, this is a question to both of you. Like, I don't know. Let's take a smash pass. I'm gonna smash pass, but instead, and somebody gets injured while I'm doing a smash pass, or they're doing a smash pass.
Smash pass? Do you mean stack? I call this stack pass, and then the legs to the side. I call smash pass. Are you referring to stack pass?
Well,
like that?
It doesn't matter.
Yeah.
It's an arm bar, and the guy twists strangely, and he, I don't know, has that like a chiropractic cervical adjustment, and he's injured for life because I'm arm barring him. I'm using a perfectly normal technique, and something goes wrong. And now in the future, we end up arguing about the standard of care, like the standard. Is it standard to do an arm bar?
The type of arguments that you'll be facing.
How do we get to a standard in jiu-jitsu, Alex? If the standard is so important, whose standard do we end up using? Let's go to other things that you've been involved with. Obviously, there's a national governing body of, I don't know, water polo. I'm imagining that the water polo standards for the national governing body would be the standards within the sport. Would that?
That's something that the trier of fact has to determine. Because you see, and I should just maybe walk us back a little bit. We have to remember that this is all based on a reasonableness standard, not perfection, right? So, and we're not supposed to be looking back with hindsight 2020, which is a real problem, because
we are,
right? So the issue is that really what the triers of fact are supposed to be doing is looking back, saying, if you step into the shoes of the people that were involved at that moment, given the standards that were governing at that time, they change over time, right? Given the standards then, was there a problem? And did that, derivation from the standard create the loss? So, that's a big question. And the point is that, this is a kind of an overarching question that we need to remember about the common law here. And that is that, in the United States and Canada, the jurisprudence on this recognizes that sport is an inherently good thing. We want to have people playing sports. It's good to have physical activity, and, it's social, and, it's generally a societal good. So the courts recognize this. It's set out in a number of the rulings. And a second factor is that there's not a sport out there that doesn't have some degree of risk, right? Even if you've got people that are just playing ping pong, people will sometimes get a ping pong ball in the eye, and it can be a horrible injury if you get it wrong, But the point is that the courts have to look at this and say, okay, well, what's the balance of risk versus standard here? And what they have to say is, what's a reasonable standard, not perfection, because you're always going to have some expert in your case that's going to show up and say, oh, he could have, should have done this. And they'll come up with a list of 10 things that everybody should have done. If they're good at what they do, what the expert will say is that it's not going to alter normal practice, that it's not going to be expensive, it's not going to be onerous, and it's not going to create a long-term problem that's going to have a chilling effect on this activity, which we see as a societal good. So if they argue it well, then, they can come in and try to say, well, we say the standard should be about this, and this is why it's a reasonable standard that we're asserting. You can see some of that language, I think, in the declaration that we've been referring to that was filed with the court that bears Rener Gracie's signature here and appears to have been sworn by him. So, he's
sort of two different declarations that he's making. Number one is this was a reckless move that should never be done on a white belt.
In general, and then this specific application of which, if that doesn't stick, then look, this specific application of this move was wrong. I can't believe the amount of comments I read on Reddit where it was just like, he did the technique imperfectly, did it improperly, which he didn't. He did not do the technique improperly.
Yeah.
The second declaration is that you should always train your white belt separate from advanced belts.
Can we read this, Stefan? Can we read this? I got it right here for you, or I did before I clipped it off. Because this is what I think the jiu-jitsu community is most interested in, this type of stuff that Rener said. And I don't think that I ultimately have a problem with him getting money. I don't think most people do, but I think most people are upset with how the industry standard was represented. If you don't mind, I'm going to read from paragraph 13, and this is an exact quote. It is industry custom for beginners to have courses separate and apart from advanced practitioners so as to ensure beginners practitioners receive the proper care and attention. Pursuant to industry standards, beginners should complete an introductory course to learn basic techniques in a safe and responsible way without the dangerous maneuvers that are used at more advanced levels. There, in that statement, which was used to justify so many aspects, what I've read in the other documents for their argument, that there's so many parts there to pick apart. One is that it's not, while it is common for people to have separate beginning and advanced classes, it is completely normal and within the standard of practice for academies not to have beginner classes and just to do it all levels. I do it like this. I'm a smaller gym, proudly smaller gym. And there are countless other gyms that not only believe that, not only can't because they don't have the student base, which isn't necessarily my thing, is that I actually think it's better for the students' benefit, both in safety and in learning, to learn in mixed levels classes. There's a lot of research on mixed level and mixed ages, if you're talking about elementary school learning, that it benefits the kids because you kind of a rising tide raises all ships sort of thing where you can have, sorry, my PC is running low. I thought I plugged it in for you guys, but you can have, let me finish. Oh, tear my thing off there. Where was I? You can have those experienced people go with the new people. That's what I do. I partner my blue belt who's there every day for 4 years with that brand new person. They already know the move and it makes everything safer for the person. I think this is more industry standard. Well, you can't argue it. Both are normal practices in jiu-jitsu. And to argue that that contributes to the negligence, which they did argue, Rener didn't argue that. Rener just says it's non-normal. But that is one element of this to unpack. The other is that, so beginners should complete an introductory course to learn basic techniques in a safe and responsible way. And I think what Rener's saying is that they should get the intro lesson, like how the Gracie Academy gave. They give on Sundays, they gave an intro course to the people who are coming to try class. It wasn't even a part of class. You do the intro course and then you go into the beginning class. So I don't know that that's what he meant, but the last part about it is he categorizes moves as safe and dangerous. And we have the safe moves at white belt and the dangerous moves at the colored belt, which is complete nonsense. As you said, that like even the arm bar contains in it risk to the neck. I mean, that's just what happens. But for both people, you can stack and your neck can go the wrong way, or on the conversely, like you could be being armbarred and somehow the legs like pile drive your head into the mat. Like all of danger exists in every movement in jiu-jitsu. It's like a bell curve for some moves. Some moves are a little bit more, a little bit less. But to conceive jiu-jitsu as safe and dangerous, safe is for beginners and dangerous is for advanced practitioners, is crazy. I feel like I'm in cuckoo land when people are buying this stuff. And this is like a big part of how he's misrepresenting. And I think it's because there are previous cases that have gone into this. I've read a few like judo cases, and I've been trying to be sold some martial arts tracking software. So, and they pitched to me that you need to track when the students come and what techniques that they learn, because this judo case, they argued that he hadn't seen this technique. The instructor said he had, the student said he hadn't. And then, all right, at what date did you teach him? And you just kind of throw up your hands and go, well, I don't know. In 5 years, I hope I would have taught him how to backwards roll, like stuff like that. So like, I think they're tapping into this because the case did get into rather extensive discussions on, well, when did you teach him how to backwards roll? What class? You don't have a log? Oh, you don't have a log? Oh, you're just throwing them in with it. You don't have an appropriate beginner class to practice these safe techniques and you're having them do the dangerous ones? That was the whole vibe throughout the entire thing. Stefan, if you could take over, or either one of you. I'm going to plug in my computer here so it doesn't die on you.
Well, Alex, you're positioned to say something about that. I'm not. I imagine there's a big advantage to being the arbiter of what the standard is, and
yeah, and I mean this is part of the challenge that we face in these circumstances of trying to establish a negligence claim, is that every case comes in with an expert like this that's going to come in and say this. So I mean, this is not different from when I'm doing my med mal cases, and we've got somebody coming in and saying, well, the standard of care for a neurosurgeon in this circumstance would be that, the following thing should never, ever be done in the type of surgery that he was performing, for a person that has these comorbidities, for example, then you'll basically have a situation where normally there's another expert that comes in and says, no, actually, it's perfectly fine for a neurosurgeon to do it because, there's a realm of, professional discretion that, somebody of this skill level, education, and experience should be able to recognize and make a judgment call. And, we shouldn't be punishing people for judgment calls if they're appropriate. But in this situation, the evidence that I see in this declaration is that, basically, Rener Gracie is saying, well, here's the standard, and if you don't follow it, you're breaching the standard. But you see, there's another part to this as well, though, that you need to appreciate, and that is that he's also very clearly stating in the declaration that there's an inherent danger with this technique, and that's where we need to remember that in California, if you're going to establish the claim, it's not just a question of the plaintiff meeting the evidentiary burden for establishing the simple negligence, right? Standard of care, breach, proximate loss, right? You also have to say that over and above that, it was reckless or intentional what this person did. So, I mean, nobody's suggesting here that it was an intention to break this guy's neck, but what they do have to do is to establish that there was a recklessness in doing this maneuver. And that's where you see a lot of the language, I think, that, you'd find in Rener Gracie's declaration here, where, he's characterizing this move in a manner that leads to that argument to say, yes, there was recklessness. And there was also arguments that the plaintiff's team was making to try and say that there really shouldn't be any sort of contributory negligence, that, really this was a situation where everything was entirely in the control of the instructor, and that, there was really nothing the plaintiff did to add to the risk here or, added to the negative outcome that ultimately occurred. So if you consider it from that perspective, if they accepted what Rener Gracie said, they applied that, and then also accepted the characterization of the inherent risks that are associated with the technique and the fact that he had other alternatives that he didn't use, and that, this inherently dangerous technique was being done against what he's characterizing as a novice, the jury can reach that conclusion and saying, yeah, this was a reckless thing that was done, and therefore, it sounds that, the boxes get checked that meet the standard for establishing this claim. So, that's where I think, we see what ended up happening here. So the real question, I think, going forward is, will courts in the future similarly accept that, you'll have a person who has his own method to sell coming in as an expert and saying, oh yeah, the industry standard is like this because that's the way I do it. And if anybody doesn't do it my way, then they're negligent.
And he posted a rebuttal to this. He read something that we don't have access to, but it is covered in this kind of summary. I don't know exactly what I'm reading, but it's actually Rener speaking and being summarized what he's speaking by some official reporter of such. That document, do you want to comment on what that document is? The one where it says that Rener comes off as very eloquent. He talks about his background. He describes the not having beginner classes as, quote, extremely concerning. What is that document that we're looking at?
I believe those were some submissions that were filed with the court. I'm trying to remember what the subject matter of that part was, but these were submissions. So what they were doing was you had a lawyer that's referring to some of the evidence and then summarizing that to the goal of trying to argue another point. So I'm just not recalling at the moment what they were arguing for at that point. But in any case, what they would be doing is relying on his opinion to say, well, this was what the appropriate standard should have been, wasn't met. And as a result of, that standard not being met, this plaintiff suffered this injury. But moreover, it was reckless that they did this. And because of that recklessness, this is why they should be getting, compensation in this situation. Because, you mentioned judo decisions and whatnot. Because, there is California, Court of Appeal decisions in the martial arts relating to instruction. And, they've had previous decisions where the courts did not grant, any compensation to people that were injured during the course of their martial arts instruction. So there was the Rodrigo and Cordio case from 2002, and there was another one called Bushnell versus Japanese American Religious and Cultural Center, and that was a decision from 1996. But in those cases, they weren't satisfied that there was a degree of recklessness here that justified any award being granted. The Bushnell one was if we're talking to a grappling crowd here, you can probably appreciate the situation. It was a situation where the plaintiff was performing Taiotoshi throws. So the defendant in the case was his instructor who was acting as buke. So he was receiving the throws. And well, as you know, with Taiotoshi, it's a technique where you spin the person around and then throw your leg in front of them in such a manner that, unfortunately, because of the placement of that leg, sometimes people land on the leg and you end up with, well, there's a lot of judoka that have multiple knee surgeries as a result of that technique going wrong. And anyway, this was an example of that. It was just a practice, and the instructor landed on this guy's leg. And anyway, the point was that the court, both at the trial level and the appellate level, was satisfied that, there was a degree of risk that's inherent in the sport. And yes, injuries will happen. And it's okay to push your student as an instructor, because one of the big issues in that one was that, the instructor was increasing the speed of the technique and whatnot, so as to make it more challenging and to try and allow the student to get better. And the court recognized that that's totally okay. And that, in that case, at least, they weren't prepared to establish that despite the injuries that occurred, that a single cent should be awarded. So, and in Rodrigo, it was a Taekwondo case. So I think a lady got kicked in a Taekwondo class and took issue with it. So anyway, whatever the injuries were in that case, again, resulted in zero quantum. There was no liability found. The idea here that, one can come in and necessarily always establish that the standard of care is at a certain level and that, there is that breach. That's not necessarily always the case. There's clearly, we've got, nearly 30 years of case law here where, there have been other ones where, there was absolutely no quantum awarded. So, the liability of the instructor was found to be zero in those cases. So, certainly the California law isn't one where they're necessarily jumping to give the plaintiffs money necessarily, but what you have to do is have the right evidence to work into the theory that I discussed and make that formula work. And what I would argue is that in this case, given, the testimony of Rener Gracie, that very much made this happen. So I think what we then need to consider
long story short, in your opinion, Rener's testimony got the judgment. Is that what you just said there at the end?
Well, it's the evidence that allows the advocates to make the arguments, right?
Yeah. Okay. Yeah.
I mean, it's kind of like,
worded it.
Fire, if you want to call it that, right? So, in the absence of that, I don't think this case would have happened. I mean, if you don't have a strong opinion on standard of care, the case just really never gets out of the gates.
So moving forward here, Alex, we're keeping in mind that we're talking to people in 50 different states, in 10 different provinces, and 3 different territories, and God knows where else people are getting this from. How does a school and an instructor keep themselves safe from losing their house, losing all future income, having their wages garnished for the rest of their life? Does everybody need to operate under a governing standard of what gets taught? Does everybody need to keep track of what gets taught when? Does everybody need insurance? Does everybody need a waiver? How do we keep this sport? How do we keep people teaching this sport without opening themselves up to personal liability? Or alternately, insurance costs that are so high, because if the courts are giving out these judgments every second case, you'll still be able to get insurance, but it'll cost you $1 million a year. So how do regular clubs operate in this environment?
Can I add to that to so you can talk kind of maybe more informed answer? Is that it's my understanding that there's no liability beyond wage garnishments and all of this stuff because you're in an LLC or whatever, that it stops basically at the insurance company and doesn't go pass forward to Del Mar Jiu-Jitsu or Sinistro himself. I don't think he's losing his pants. I think by the insurance, as far as I understand it, and as far as Rener understands it, as far as us jiu-jitsu laymen's understand it, is that by fighting the case, it now puts the insurance liability or the insurance liable for the entire judgment amount, and it doesn't transfer over. It's not like they cover $1 million of it, and another 45 million other goes to them, and they have to declare bankruptcy. That's my understanding, is that's not true, and that the insurance company just pays out, which is an important point here. There's a little undercurrent and that I don't know if you want to ask me about. We'll probably forget about it because there's already some major things that I wanted to get to as far as some of the stuff that Rener says. So go ahead, Alex.
Yeah, well, here's the point. At the end of the day, actually, what I guess has been suggested about the ultimate risk, that's not accurate. There's no limit to your personal liability, ultimately, unless you structure your life in very particular ways. And there's a number of tools you can utilize to reduce your risk. So the field of risk management gives you a number of different options to consider here. So let's just talk about the doomsday scenario first, okay? And that is, try to imagine that you're a business person and you've got this business and, there's this bad outcome. Now, we probably it's important actually to unpack the relationships here, because we haven't actually talked about who the different players are, because okay, if you go to the style of cause, you'll see that the plaintiff, this is a fellow named Jack Greener, okay? And he was suing 4 defendants. He was suing, no, I'm sorry, 3 defendants.
Jiu-Jitsu, Michael Phelps.
And Michael Phelps and Francisco Antonio Iturralde Lara. So the relationships are this. Michael Phelps is the owner of the business, which was M. Phelps Incorporated, doing business as Del Mar Jiu-Jitsu Club. So if I'm understanding things correctly, the claim primarily was against Michael Phelps and Michael Phelps Incorporated. If he's got the incorporation done properly, all the contracts are done properly, everything's clear that people are dealing with the company, then you can sort of compartmentalize your risk by saying all the risk is with the company, not anybody personally. But I can see in this case that Phelps did get sued personally. So I'm not sure whether there was some sort of an argument here that we're not seeing in the filings that led to the fact that one could conclude that Michael Phelps personally was providing these jiu-jitsu services, or that he was personally involved in some way and not his corporation exclusively. But anyway, here's the point. When we talk about Francisco Antonio Iturralde Lara, he's an employee of M. Phelps Incorporated. So he's just an employee. He's not, an individual that's running the business himself. He's named as a defendant, though, but the arguments that I saw that were made were that this instructor was vicariously liable, or I should say that the company was vicariously liable for whatever he was doing in his employment. And that's quite standard. If you have somebody that's in the course of their job and a bad thing happens, usually it's the employer that's ultimately responsible. So anyway, the point is that there's ways that you can reduce your risk. If you're an individual and you're running the business, if you incorporate, you can try to compartmentalize your risk. If you're making it very clear that everybody's dealing with the corporation and not you as a person, personally, that's one thing. And why is this important? Because if you're the business owner, or say it's not just a corporation, but say it's you yourself, and you've got, let's say, $1 million of coverage. Maybe you've got $10 million of third-party coverage. That means that the insurer has agreed that you have a total risk, which could cap out at that amount, and they've offered you a premium to cover that risk up to that amount. But the insurer has no obligation beyond whatever they've contractually agreed to be the top end of the risk. So if there's a $46 million award against you, the insurance will cover the first 10. The other 36, they're looking to you personally for it. And that's where you mentioned bankruptcy. I mean, that could be the ultimate endpoint, because judgment is a form of unsecured credit. Basically, a judgment debtor is an unsecured creditor. So they would be like, they would be lining up with your Visa card and anybody else that, you've borrowed money from or whatever. And they'd all have to go down and try and sort out whatever your eligible assets are and run through the bankruptcy process as it's governed in the jurisdiction.
Oh, really quick. One black belt lawyer who's a student of mine said that in California, that the amount, if they fight it and the amount goes over, that you're not personally liable for it. I don't know how correct that is. It wasn't their field of expertise, but that was how I understood it. So you're saying that over his insurance amount, that he's going to have to basically declare bankruptcy, and they'll have the creditors lining up at his door.
What it's going to depend on is whether the plaintiff's lawyer chooses to go there and go after all of that. You will have circumstances where they look at it, and I mean, let's face it, there's a lot of people out there that really have no exigible assets and they have no other revenue streams or whatever. So even though you've got a $36 million judgment on them, it doesn't mean anything because you'll never collect it. We call that a dry judgment. That sort of thing happens all the time. So, unless they have researched this and figured out that, this fellow's got nothing, then, there is a potential risk there. Now, I don't know whether in California they have some sort of other limitation of liability rules that would somehow make that different. But I mean, at least, where I practice, when there's a problem with the sufficiency of coverage, that's a big problem. We need to make sure that, as if you're defending one of these cases, that you're doing everything humanly possible to try and keep it within the amount of the insured limits, because otherwise, the the outcome for the defendant could be very, very problematic going forward. So, I mean, in terms of if you're a business person, there's a few things you can do. I mentioned that, incorporation can be one way of containing your risk. Making sure that you've got up-to-date contracts that you're utilizing when you sign people up is good. You want to make sure that you're very clearly stating, who's providing the service is the corporation, right? And that, they're agreeing to have, a waiver as part of that agreement. But here's the thing, you need to make sure in that waiver process that the person actually appreciates what a waiver means. And this is where the wheels fall off on almost every waiver that you tend to run into, is that it's included within a document with a whole bunch of legalese, and it's buried somewhere within there. Oh, by the way, you're signing away all your legal rights in the future if something bad happens. And the problem is that unless you draw it to somebody's attention and you say, do you understand that you're signing away your legal rights in the future? Do you appreciate that? If they don't say, oh yeah, I read that and I get that, then the value of the waiver is negligible, because they'll just say, well, I didn't read it. I didn't understand that. I didn't agree to that. So even though they've got your signature on there, they'll deny that they actually appreciated, what they were signing away. So that's where the judges can come in and say, well, no, I'm not satisfied that this waiver, was drawn to the attention of the plaintiff to the degree that they should, preclude this person from seeking their remedies. So, if you have systems in place where you ensure that every time somebody signs one of these things, that somebody checks off that I made sure that they understood what the effect of the waiver was. They confirmed with me that they understood what this was. Have 2 or 3 questions where there's a witness to the agreement who's confirming that they checked with this person, that they understand the significance of what all this is. If you can sign off on that, that's putting you in a very different place from where most businesses end up, where they've had a waiver that somebody's just kind of signed off on without addressing and acknowledging, what was really signed off.
For what it's worth, Alex, and it's coming from Rener when he was talking to Tom DeBlas on their Instagram Live. So I don't know if this is a jiu-jitsu guy's interpretation. This is a jiu-jitsu guy's interpretation of what a jiu-jitsu guy interpreted in a court of law. So take that with a giant grain of salt. Apparently there was a waiver in this case, but it was so poorly written that the judge deemed it inadmissible, and thus this case went forward as if there had been no waiver at all. So that's all the information I have. It doesn't come from a transcript. I don't know if that's, to what extent that's my misinterpreting somebody else's misinterpretation. But I think having a really good waiver, that's checked over by a lawyer is probably a good idea. In your jurisdiction is probably a very good idea.
This is the key thing, is that every jurisdiction is different. So you want to make sure that you're talking to a lawyer in your area who understands, what the local rules are, and that can inform you about, some of the salient issues. Like, there's another one that people need to be aware of, and that is, depending where you're working, if you have a waiver for children's classes, for example, is there an ability for a parent to sign away the rights of their child in your jurisdiction? Some jurisdictions, you can't do that. So there's no such thing as a waiver you can get for children. They just don't exist. So, and children can't sign it themselves because they don't have legal capacity. So, if you have that situation, then you may have a group risk here where you're saying, well, if I teach children, guess what? There's no waiver for them. That's not going to have any legal effect. So how do you deal with your risk with respect to them? It's going to be insurance. It's going to have to be, making sure that you train your employees properly, that you get, some sort of safety standards that you can point to that seem to be in line with what everybody else is doing. If you can do that, then, you're in better stead. Where things get complicated is, if you have experts who are coming in and suggesting that the standard is higher than what it really is in the general industry. So you've got to ask yourself what would be the actual standard that should be governing.
And this is like I opened with, is that this is what bothers me about it more than anything, is that we have Rener representing the standard of care within, or standard practice within the community. And you get things that are just so off the wall. I don't think he came in with the intent of, I'm going to represent jiu-jitsu the way it is and the way that it's practiced. I think he saw the video. He said, we need to make jiu-jitsu safer. Just in general, he has this idea of he wants to make jiu-jitsu safer, where people aren't quitting their first 6 months. That's why they don't spar the way that we conceive, that you and I conceive sparring, until they get their blue belt. They do kind of like the very limited specific training and choreographed movements. This is all kind of part of his ethos, if you will. And I think a large part of his motivation for this was contained in his brother's Instagram tweet. What do you call it on Instagram? I don't have Instagram. But his post where Rener asked, what do you think? He didn't ask it the same way that the jury asked it, but he essentially said, what do you think about the standard of care in jiu-jitsu? And Hedron posted in big old caps letters, he goes, too low. And I think that ultimately encapsulates kind of why he was participating in this. I think to his own ethos, to his own constitution, he is acting sincerely. He sincerely believes that jiu-jitsu is far too dangerous the way it's practiced by most people. I think that was a lot of his motivation. I think at a certain point when he kind of came of age, he asked himself, what are my contributions going to be to this martial art? And there was a couple of things that he tried that didn't work out. And I think ultimately he settled on, I'm spreading to jiu-jitsu to the most amount of people possible. And which is a noble goal, that's okay. But I think he did that through essentially watering down the sport. He did it through lowering this, not standard of practice, but lowered the standard of jiu-jitsu. He kind of like watered it down, is the whole word for that, because I think the way that most people conceive how he does his combatives program to be a watered down version of jiu-jitsu that produces horrible jiu-jitsu practitioners that are overconfident and non-technical. And I think he sees this as part of his greater vision for bringing people into jiu-jitsu, for getting them to fall in love with it in this kind of like pseudo jiu-jitsu state, and then hopefully hook them later. And I think that he saw this trial as an opportunity to change jiu-jitsu systemically, if you will. And I think that's why his testimony was what it was, which is like, it's hard for me to grasp whether he is just ignorant of the way that people run their academies, which I did consider that, because he's been in his own little walled garden for 20 years, surrounded by yes men. Basically, he's kind of worshipped over there. You know, all of the Instagram comments are kind of it's kind of like Elon Musk, you know, he has his own like very closed walled garden of people that support him. So I'm kind of thinking maybe he just doesn't know the standards. I think there is a little bit of that. I think there is a little bit of this going on, that when he says things like, can I just pull this up really quick here? Because I actually do want to get into some of these quotes, which were kind of frustrating for me. So he said, I don't represent my standards as like the way that everybody should do it. But he says like in the same breath that like it's weird the way that Phelps was doing it. He says like the belt system and reason for belt system. There are schools where white belts are taught different techniques, then take more advanced classes. It appears that Del Mar had no distinction in skill levels among students in a given class, which is a, quote, huge concern. Most schools have a separation. Like, where is he getting this? Is he ignorant of the way that people do this? Most schools, I mean, it's more or less 50-50. So there's what, to my original point, is he just like ignorant now that he's 20 years removed from like any sort of like real training, forgive me? Or is it just like he is actively seeking to change the standard of jiu-jitsu? And I like to read this other one because there's basically two things, and they were used extensively in the trial that I kind of, in various points. And this one here, I know, Stefan, this is going to drive you nuts, but where he segregated out and I think this is sincere. I think this is sincere Rener. He segregated out the techniques that you use in a competitive environment are of a fundamentally different nature than the techniques you do in what he called instructional sparring. This makes me want to break this tablet right now, because
I had forgotten about that. Thanks for reminding me.
Yeah, and it's because I start somewhere and I have intent of going there, and then we talk about, some legal things which are awesome. But I think most people aren't academy owners. Academy owners like me and you were scared. Or like get the new white belt in who's a little bit aggro, and you're like, you're not sparring today, even though I normally would partner you with my big old purple belt that can absorb that. And I'm not going to do that. I think there is that, but I think most people are just like, what the heck is Rener doing? So let me read you this. And I'd like to actually talk about this on a jiu-jitsu level first, and then on a legal level second, which he's already kind of answered, which is he's representing the standard of care, and that's very important and whatnot. He says, quote, instructional sparring and competitive martial arts are starkly different, such that they are essentially two distinct activities. See, they're different. Competitors at the highest level of martial arts use techniques which are not commonly utilized during instructional sparring. A dichotomy exists between the risks in upper echelon competitions and instructional sparring in a class. The forward flip backtake is not typically performed in instructional sparring, particularly where a practitioner receiving the technique is of lower rank and or skill. I feel that this needs a sentence by sentence, like deconstruction. Stefan, if you don't mind going through this together. Instructional sparring and competitive martial arts are starkly different, such they are two essentially distinct activities. No, they're not. You may roll harder in a tournament, but you are not fundamentally doing two different things. And this, I can say with certainty, is Rener being sincere. He's not trying to guide it, because this is how he views it. This is how he views martial arts. He views it in the sense, through the lens of his combatives program, and that's the lens in which he's viewing it. He is so far removed from competition, and the techniques that he teaches are so different from what you and I and Atos and Andre and AOJ, all those people are teaching, that in his mind, they are two distinctly different things. And they are. Have you ever had a Gracie University student come to your school? I apologize. This is going to catch me some flack. Have you?
I have definitely rolled with some Gracie Academy blue belts.
Academy, so you're talking a while ago.
Yeah, a while ago.
Okay. And I'm in Southern California.
You could tell. You could tell. Like, you put hands on, and it's like, this person isn't moving like a blue belt. Like,
yes. Immediately. Not only have I regularly interacted with people from certified training centers from Gracie University, and before that, Gracie Academy, but I've had online blue belts come to my academy, and it is so, like, the word that describes it is embarrassing. And it's embarrassing to such the level that the student who's coming in, I'm not trying to embarrass them. I'm trying to help them. I try and help every single person that comes through my door. But at the same time, this person has the self-awareness, not person, it's many people that have come in. I'm specifically thinking of one example, which was the Gracie University online blue belt that came in, was self-aware that they did not deserve to be wearing this belt. And it wasn't because like he had been taught techniques that were like similar and he just wasn't good at it. It was a fundamentally different activity that he was doing. What he was doing was not what you and I do on a daily basis. So this is the world of Rener. He is telling it as sincere as he knows it, which is like, okay, sometime way far down in the future, sure, way far down, this is not what we do, but some far down, you can maybe start to engage in this different activity, which he considers competitive martial arts. And that's so fundamentally different on a technical level than what we're doing here in rolling. And can you add to this discussion? Because I don't want to be the only one. I feel like my voice here is the voice of 99% of people. And the only people that my voice in pointing out the craziness of the first sentence, we haven't even got to the other sentences, is like,
I'm
like
very happy to go.
Community. It's not me saying this. I would represent the community. If I was asked this, I would say, I'm not doing anything that I feel is misrepresenting the community for your lawsuit. I'm sorry. All right, go ahead.
I totally agree that with a very few exceptions, that there's really not a difference between, what is it called? Educational sparring or
No. Instructional sparring.
Instructional sparring and competition. The intensity is different. There may be a
and
few
not
techniques
for everybody.
I'd
like to add, not for everybody. When you travel around, there is different levels of intensity, and there are many gyms within the standard of practice that roll hard.
Sure.
And this is all wrapped up into the whole what a spaz thing is. Like in America, because of how we were presented martial arts in the beginning, trying was considered a spaz. That's in the beginning, in the 79 Horion's influence and all that good stuff. Technique only, no strength. Technique only, no strength. To the point where if you actually try, you're not spazzing. You're not doing unintelligent movements. But my point is that many people do roll hard. I'm in Southern California. If we don't roll hard, we get killed. We compete against AOJ. We compete against Atos HQ. We compete against Checkmat Headquarters. We compete against Lucas Leitch. These kids, all these gyms are freaking good gyms. Homo Bahao. If we don't roll hard, but hard but safe. You don't have, hard is not like unsafe. So I just want to say that I don't even know that I disagree that it's without like abnormal to roll hard. And I get it. It is for a lot of gyms. The many visitors that I have come in, I'm like, please, you need to go hard with me. Please try and tap me. Don't go light. Don't go light. If you're a purple belt, you're going with my blue belt, who I know is really good and probably better than you. I want you to go really, really hard against them because this is our culture. And we all smile afterwards. And I think that's the culture at many gyms.
Let's put a pin in this because I know Alex has a hard out. So I just want to get, if you're a school owner and you want to some extent insulate yourself from these accusations that what you're doing is a departure from the norm. Let's say you have a different way of teaching. Let's say your philosophy says, you're trying to do your best. Do you have to then be able to reference some kind of governing body? Like
if
they had said this move is not illegal in the IBJJF, which is the closest thing that we have to a governing body. If that had been
or Henner's own organization.
Or Henner's own, or would that have been a better defense? Like how does a school owner insulate themselves against this claim that you're off on, that I'm off on planet Kesting, doing my own demented thing, and that's why this guy got hurt?
You have to have a lot of expert witnesses, I would imagine.
Yeah, I mean, what it really comes down to is that, you need to be able to establish, not that there's necessarily a governing body. I mean, it's very helpful when you do have a governing body because they do tend to create rules and structures and whatever. So it makes it easier for the trier of fact to look at this and say, look, here's where, it's been written down and, there's so many thousands of people that are part of this organization. Therefore, they all do it this way. It makes it easier for them to reach that conclusion, but it's not the only way to do it. I mean, you can have an unwritten rule that goes through, an entire field. The only way you're going to learn about that is through experts. You've got to get somebody that's experienced and whatnot in the field. And that's where the expert would come in and hopefully accurately represent what that is. If they don't accurately do it and you don't have a way of either attacking the testimony of that expert effectively, or you're not able to bring in an expert of your own that's able to try to bring some reality to the situation, then you can end up with, unfortunately, situations where perhaps an incorrect idea of what the standard should be ends up becoming, the evidence that, governs the particular case. But ultimately what it comes down to is that, they're going to need to have, appropriate expert testimony on that question. Another way is, to have associations where they do address these points, and do cover off these points and say, well, it may well be that this organization says that it should be done this way, but, here's our association of independent academy owners, and, we've got 200,000 members across North America, and we don't do it that way.
Stefan,
I don't have a hard off. Do you want? Can we continue a little bit, Stefan? You and I,
100%, 100%. We'll cut Alex free. Alex, thank you so much. Let's train this week. I'll text you. We won't schedule it here, but
Alex,
we
got to train together. Come to Southern California. Come to Worlds.
I'd love to do it. So yeah,
I haven't
it's
even
been
trained
pleasant.
with Steph
Thank you
and
very
other
much.
side.
Okay. Be it resolved that there is a difference between the sparring that should be done in class versus the rolling in competition. I can't even argue that as a
The
straw
reason
man.
he's making this argument is that the Leo Viera Backtake, which is called the forward flip backtake, is a part of that world, not this world that you are learning in. And that is such an egregious level of misrepresentation. And I don't feel that somebody who's been doing jiu-jitsu for 4 or 5 years has been through probably what we have been through with a lot more experience. This is not coming out of the woodworks with Rener. It's not coming out of the woodworks with his dad, and it's not coming out of the woodworks with his grandfather. This is like a long pattern of history of kind of twisting things to suit their narrative. This isn't coming in a vacuum. There's a reason why when I read this, it connects with that entire like history as well and makes it like you can already see the soul of what he's trying to get at here.
Yeah, I mean it's if you take this to its logical conclusion, then really until I don't know, blue belt or so, you shouldn't really be sparring at all.
That I really sincerely believe that he would see that as a step forward for the martial art. And I think, I mean, obviously he didn't testify that. This is just my opinion. But I really think that he would see that as a pretty much win that would open up jiu-jitsu to the masses. And you know what? You would increase probably the amount of attendance if you didn't have to experience what we experience, and there is a little bit of natural selection, and that's kind of part of the deal. That's what makes it so great, is that, not everybody can stick with it. Not everybody can handle the ego crushing. And it's not like we're in there, I'm going to crush this guy's ego. Just like normal rolling, you lose like you do in the beginning. And for some people, that's a problem. For some people, they do get injured. And Rener, I think, kind of sees it. He's not now, because now he's under the limelight. I think he would kind of like to nudge the sport in that direction. And I think that's what he tried to do. And that's infuriating. The things that, I'll just go back to my whole, if somebody's like what irritates me the most, my pet peeve, is people taking over the narrative of jiu-jitsu. If you want to get me riled up, that's a way to get me riled up. I don't care if somebody like says their own little thing, but they like flow grappling. That's my pet peeve as well, because they kind of like try and take control of the narrative of jiu-jitsu. And I had a little like inside window into how they came into the sport, because I was being subcontracted by Voodoo Videos, and there was many things that I didn't agree with, and I saw them do things on a nuanced level. But like these, and I was the first outspoken person on flow grappling, by the way, for those that don't know the history on that. I'm excommunicado. I've been excommunicated from the flow grappling world, to the point where my students can't even get mentioned when they win PANs. But I digress. So my pet peeve is narrative takeovers. And that's what Rener is trying to do. And he's trying to do it in a legal sense. So,
yeah. I mean, in a certain sense, the Gracie University approach is kind of a recasting of the original. Like, first, there are different lineages of jiu-jitsu within Brazil. There is the Gracie lineage. There are other lineages. I mean, Robert Drysdale has done a great job of documenting this. And within the Gracie family, there are different lineages. There's the Helio branch. There's the Carlson branch, to pick the two biggest ones. And they did things very, very differently, right? I mean, Carlson taught anybody, and there was a ton of sparring right away, and a reasonably big emphasis on physical conditioning and cross-training, seems like.
And it wasn't just those two. There was other branches as well.
Yeah, sure. But
and
within the Helio-Horian and now Gracie University branch, like back in the day, you couldn't go and just train. You did a whole ton of private classes. It was very expensive to train in Gracie Jiu-Jitsu back in Brazil in the 50s, 60s, and 70s, because it was a long series of private lessons before you got anywhere near being able to spar.
And I'm sure you remember one of the common criticisms was that they held back from their students unless you were in the Gracie family. Yeah,
for sure.
in family.
So in that sense, Gracie University, where it's a long time till you spar, and there's a whole set of things to go through, that's consistent within their lineage. But there are other lineages, and it's
today they're like, you have your bell curve of jiu-jitsu academies. Look at this. Where's the end of my screen here? They're over here on the bell curve. It's not like they're here and producing like a minority view. They are literally over here. And they do a lot of outreach to new people through when Rener was doing the Gracie breakdowns and things like that. He was bringing people into the sport, and not just his world, but primarily into his closed wall guard room. And I think people don't appreciate how much that Rorion coming here as the first academy of note influenced American Jiu-Jitsu. And I feel that we are still playing out the consequences for the way that he manipulated the story of Gracie Jiu-Jitsu. Completely, like...
Give me an example. You mean like the no
Elio
strength, just technique?
Gracie Academy. I'm sorry, I didn't hear you. I talked over.
Give me an example of what you mean. Are you talking about like the
no
strength, just technique narrative?
No. Yes, but that's a whole part of it. Rorion is on virgin land, and he can tell whatever story that he wanted to about what jiu-jitsu is and what it contains. And he cut out everybody from Elio on up to him. So all of the advancement that was happening in Brazil, most notably through Hall's Gracie, incorporating different, born of the son of one, raised by the other, training sambo, training judo, training jiu-jitsu, when that in a time where you didn't really do that. You were, the way that Elio tells it is that, and the way that Rorion told it through Elio, is that Elio created the art of Brazilian jiu-jitsu by modifying the traditional techniques that they had in Japan, introducing things like greater leverage for somebody who was weaker. And what he created at that time was a perfect art. This is a narrative that's been forgotten, that only the athlete could err in their application of the perfect art. And what Rorion was offering when he opened up the Gracie Academy after he got done with the garage was he was offering an unwatered down version of what Leo Gracie created. Not all the stuff that had been gobbledygooked through the generation. Turns out it wasn't gobbledygook, it was called evolution. So we got, in the beginning, we see a hoist win, we sign up, we got this very old version of jiu-jitsu when Brazil had this huge head start because they didn't live in the world, most of them, there's some that I'm sure did, but most of them had benefited from the evolutions of Hall's. Rickson is the most interesting grappler ever because he's a son of Leo Gracie. He's heavily influenced in philosophy by Rorion, who is kind of like this, but taught by Hall's. He's a walking contradiction of a man because he embodies nothing about Leo Gracie Jiu-Jitsu. He embodies Hall's Gracie Jiu-Jitsu, an aggressive Jiu-Jitsu, one that was experimental in bringing in different types of techniques and strategies. You look at Rickson compete. Is that Leo Gracie defensive first Jiu-Jitsu? Just let him get tired. There is a little bit of that. He's got 1 foot in, 1 foot out with his dad trying to please him, and Rorion's kind of being the philosophy guy, but Hall's is clearly the superior of everybody. That was a whole friction point between Elio, because Elio wanted Rorion to be good, but Rorion just wasn't good, and then Hall's was better, and that was a big source of resentment for a while. But anyways, more to the point of like how this influenced America coming here is we got that so-called pure water jiu-jitsu. Does that ring a bell to you, the pure water phrase?
No, I've not heard that.
Oh, really?
But I'm familiar with
pure
the
water
general gist of what you're saying.
So this was anybody that maybe being around Southern California would be at this time, and including when Rener started to take over, I literally have heard Rener say this exact spiel, is that you are learning the non-watered down version. You're learning the pure water version of the original martial art as intended by Leo Gracie, and that everybody else didn't have the same teaching methodology. Everybody didn't have the same superior technique. And in the beginning, they were warranting that they were superior for fighting. And then they got marginalized and the jig was up in fighting. So they kind of pivoted and they said, we're just doing, yes, this fighting, it has rules, it has time limits. This is not the true representation of what a self-defense is. And then they started to pivot a little bit onto the sportive side to take out the brutality of fighting. And they said, we're superior there too. And then it turns out they weren't superior there too. That was when Ryron was doing all the challenge matches, when he was much younger, against Mark Lehman. That's when Travis Lutter became the Michael Jordan of jiu-jitsu by beating Rener Gracie 12-1. Ask yourself, how do you beat somebody 12-1? And you will have a very interesting answer, is that Ryron...
Or Wally Ismail choking out Hoist. That was a mic drop moment. I was like, oh my God, how could this have happened?
And that was when matches meant something. You were fighting for some ideal. And Hoist was in there to show the superiority of his basically his whole essence, the whole essence of what he valued in jiu-jitsu versus somebody else's essence. And we don't have matches like this anymore. I think the last match that took place, it was like an essence of this, was Ryron versus Andre Galvao. After, rewind a little bit, they got marginalized in competitive jiu-jitsu. Turns out they couldn't win there. And then they retreated into this corner of, here I am just in this for self-defense. We're for untrained attackers. Trained attackers have different types of reactions. Untrained attackers have different types of reactions that you need to prepare for, and you'll build in the wrong reactions. So they can exist in this like almost unscientific, because it can't be tested in a real type of scenario. Can't fight in MMA. The rules are a little bit weird, not conducive to a self-defense situation. And competitive jiu-jitsu don't want to do that because people are just, that's not a fight either. So they get to exist in this little tiny sphere of the self-defense thing. And back to my overarching point is that this is the jiu-jitsu that we learned early on in America. It was, when I started here in Southern California, it was taboo to try. It really was taboo to try when you roll. It was just like you were using too much energy. You have to just learn the technique. Every part of the move, every single thing, your fingernails in the wrong position. They wanted to micromanage this. And this type of jiu-jitsu really held us back in the beginning. And we're still suffering from the consequences of it.
In the competitive, when you say holding us back, you mean in the competitive, as judged in competition?
As judged in competitive jiu-jitsu, and the people that are interested in fighting just go to MMA and pursue that at a high level. So,
well, it's easy to say, if your fingernail must go here, then here's an injury that happened to take us back.
Exactly. That was part of a even
this would have been prevented.
Point.
This could have been prevented if we had just been doing it as in the backtake method as taught by Helio.
You are hitting on such an important point. It's not as Elio, because Rener is not his dad. Through each generation, it softened. And when Rener came of age, it's a very tough line to toe to say that the techniques are unchanged since the time of Leo Gracie. I mean, that was the Gracie Academy. That was the Gracie Academy when Rener took over, and he's kind of softly waited for Elio to die, and then started to do the combatives and the online stuff. And that was, I remember one conversation.
And the selling blue belts online there. I mean, that they're no longer doing that, but that was a gig for a couple of years.
Yes. Yeah. And that was one of the people that I described as that online blue, but I've also had in person, and it's all the same. It's all the same. You don't spar, and you're being taught
No sparring, no
very,
miracles.
but it's not even just the no sparring. I could probably get somebody reasonably functional with no sparring. It's the techniques themselves that are just antiquated. They're like the stuff from the old self-defense stuff that some people still insist is like better than the stuff today. And you're not teaching like bear hug from behind, drop into a knee bar. That's the type of nonsense that's not in the combatives. That was dropped from the combative. That's the type of techniques that were unmodified from Leo Gracie. And as I started with it just a moment ago, I was witness to one conversation which really perked up my ears between Rener and Huron. And no way they would remember this. I don't even think they would remember me. 3 months, some kid that just won't leave the gym. Like, nah, they're not going to remember this. But they were talking after class. Rener was being super obsessive about like taking every little black mark off of like a special sign that they were going to put out. Every little one. It had to be like, I'm talking little ones. The sign is enormous that you can see from the street. That's kind of his personality. It's very meticulous. It's very like fingernail needs to be in here to do this technique. That's kind of the way his brain works. And the way that my brain works for a while, I needed to learn to just do the freaking move. Just here's where you're going. Just get there. I needed to overcome so much in my jiu-jitsu because of how I was brainwashed. But back to the conversation. They were talking about techniques within this context of putting up this sign. And I don't even remember what the technique was, but it was something to the effect of, Dad does it like this, but I don't like this. I want to do it like that. That was one of the most interesting conversations that I had witnessed, because everything publicly, their whole sales pitch was that we have not modified this. We have not changed the techniques since Leo Gracie. So I'm trying to say that like Rener has changed things, not that much, mind you, but he has softened and refined, if you will, to a certain level. He is a little bit more open-minded.
To give him credit, he did compete. And he didn't do great, but he didn't do terrible.
Yeah, that's fine.
But he did go try it out. And I'm sure as when, the bug of theory hits the windshield of reality, you go, holy shit, maybe I better change, modify the ancient scrolls. The techniques on the ancient scrolls have been handed down to me. And I better, not put myself in a triangle choke to try and pass the guard. To take one of the classic examples of something that was probably in the old jiu-jitsu.
What Stefan is referring to, dear listener, is the Gracie gift pass. If you want to hop on Google and Google Gracie gift pass and go to the Gracie Instructional Volume 1 and see that, you'll scratch your head and go, what the heck? Yeah.
Well, so basically, yeah, you're in the guy's closed guard. You break the closed guard open. You put one arm under. You put it yourself in the triangle choke, and you're
missing the important element here. Not only do you put one arm under, you lean your shoulder all the way down.
No.
And you know what?
But we were taught when we were just having this discussion 30 years ago. It's like, well, a friend of mine went to a Rener Gracie seminar, paid $400 for a Rener Gracie seminar.
You know how much Rener's are? $1,600 a head. That's what he charges law enforcement. $1,600 a head, and there's like 60 people in the room.
Nice work if you can get it.
Yeah, I agree.
Anyways, the key was if you're doing every detail correctly. If you missed even one detail, then you were going to get triangle choked. But like apparently there's this it's a no true Scotsman argument. Oh, you tried this pass and you got triangle choked? Well, you didn't do it correctly.
Yes. This is what I'm saying about holding back American jiu-jitsu, because you cannot think in this way. This perfect. Things are perfect and imperfect. They're black and they're white. You can't think in this way and be successful in jiu-jitsu.
In the aftermath of this trial and in the aftermath of this settlement, are you going to do anything differently to protect yourself?
Yes, but it's not. Like
presumably
I
get a better legal defense team.
Yeah. So really, if the I need to be careful because if I open this can of worms. But if you Google Rener's name, my name is going to come up as a critique to Rener Gracie because I've done it many times. For example, when Rener told Renzo's student that he didn't know jiu-jitsu from the real... Renzo could not verbalize what Rener said, but he was pissed off at it. I made a video. It was like almost like a music video to the podcast interview with Renzo, just tearing Rener a new one. Because Rener gave a speech that I have heard him give, because I used to help him on Saturday or Sunday, I think it was what it was, give those introductory classes to the new students. They wouldn't incorporate them into the class, as I mentioned earlier. They would have them a separate, it's your first day in jiu-jitsu, you get your first lesson thing. And I would hear the sales pitch that he gave, and the sales pitch that he gave would piss off anybody else, like Rener Gracie. And Renzo just went on this tirade. I think it's like titled Real Jiu-Jitsu. If you do Real Jiu-Jitsu, Rener, you'll hear that. And I made this video putting pictures and images to it. It's almost like an anthem, because for a while there, Rener was really attacking sport jiu-jitsu as not being able to defend themselves, that was making me very upset. Then he did the Jeff Glover interview, and even though he talked over him, I was like, okay, Rener's leaving us alone now. He says that sports jiu-jitsu people can defend themselves. I'm just going to leave Rener alone until today.
Well, I mean, your fervor on this topic. I was going to make a joke earlier, like, tell us how you really feel, but I think you have done that. I can really only compare it to ex-evangelicals, right? Like somebody who used to...
Hallelujah, Stefan. I feel like a more sane when I talk to you. When I read the comments online, I feel a little bit, I get boiled. I'm like, okay, I'm driving down to San Diego. I already know what Rener said. I'm going to drive to San Diego and I'm going to get you the exact quotes for it. I get so angry because of how the narrative is being controlled, because Rener is very eloquent and he's very persuasive. Yep. And it's unbelievable that he can do it for random jiu-jitsu people. He can do it for the jiu-jitsu community. And I don't even think I've scratched the surface on all this. I think that I would need to go through not only his declaration line by line, because I can do that. I just brought up the two things right there. I essentially provided three forms of unique commentary. One, I gave the technical analysis of Rener's technical analysis, which is garbage. Mm-hmm. Two, I gave my analysis, I guess there's four. I gave my analysis of the move in general. Three, I gave how he misrepresented jiu-jitsu by saying that it was extremely, what was the word? Extremely concerning and not the standard of care, not have white belt classes. And fourth, how he tried to segregate martial arts instructional rolling as fundamentally different techniques than those you engage in the tournament. I think I've only done those four things. Dude, I have more than four things. There are more than four things floating around in there. But because if you start to pick apart line by line, it's like, okay, he says that jiu-jitsu is considered the most the gentle art, and it's considered the most safe of all the martial arts. No, it's not.
Tai Chi is the safest.
It's not. It's not even close to the safest martial art. You are engaging in a sport with risk. But he doesn't see it that way. It's not the way that he conceives jiu-jitsu. You can go line by line.
I will grant him there is less risk in the way that he teaches at the expense of making people who can't defend themselves and can't compete.
Yeah, it's true. And when you combine those things that I said, because I think people bought his technical analysis because they've never analyzed anything ever. And two, I think it's okay to conclude that maybe this move is too dangerous, but you're concluding this after the trial with hindsight. This is not the standard of practice in the community before this accident, if you want to make it afterwards. But
yeah. Again, there are moves that are more that you would probably only do at full speed in competition. I don't know, like say you have a good suplex, and let's say we're just sparring and I try and stand up out of turtle and you get me in a rear bear hug. You're probably not going to suplex me on my head if we're sparring.
Well, probably. Okay, I have an easy counter argument. This is why I should have been the expert testimony, is that you are not permitted to spike them on their head in a suplex. This is explicitly banned in the IBJJF. It's banned in other organizations too. It's banned in high school American wrestling, to where you need to deliver them with control onto the mat. So Like that argument to me, like is you use suplex. I don't think that's the same thing as I get what you're saying. I understand your basic point. There are some moves that you don't.
Even just, I don't know, Seoinage when you're throwing somebody really hard, when you're just trying to knock them into next week and knock them out with a mat.
Yeah, Henner's argument is essentially you didn't teach him a break fall, and then he got hurt to accept the throw. That's essentially his same argument here. So what are you not going to do? You're not going to do Seoinage? Yeah, I mean, yes, I'm going to... Hey, I'm a guard puller, but I did it. I did judo as well. If I do Seoinage, yes, I am going to kind of pull back on a student who's brand new. I can feel that they're brand new, but if they're not brand new, I don't care what belt they are. You have to go hard on the movements. There's certain movements, it's like in the throw category, in the Leo Viera Backtake category, that you can't do slow. If you do them slow, you end up like Chael Sonnen, falling off the top and immediately losing to Fedor. You know what I'm talking about? Please tell me you do. Yeah. So, as far as your question earlier that I didn't answer, what am I going to do differently? Is that it's not going to be the legalese that I'm doing differently. I'm not doing Henner World differently. But you know what? When I get that guy that I know has in him, like I have two students. Okay. Elder, I hope you're watching. So I had Elder Cruz's brother come in the other day. Elder Cruz's brother has wrestling experience. Elder Cruz's brother, if you were to imagine something in your mind, imagine Orlando Sanchez. That's who this guy is. And this guy with wrestling experience, he was going. And, you know, I'm super nervous. I asked one of my top students, no one, I was like, Elder Cruz, he came in, he said some things, you know, he's a nice guy, but he said some things that were a little concerning, where I know as an instructor that this is going to be a little risky to have this guy rolling, even though he's experienced, that I should probably not let him roll just yet. Those types of situations where I know it's just not feeling right. I have two students, normally not, to be honest with you, because I am a small, tight-knit school. And I have another one that recently joined. He's 6'6", he's 240, and he just goes crazy. I think he has a little wrestling experience too. That he's just going super duper hard with people, not aware of his body. And I think it's those situations where we actually know that there is a safety risk. Because honestly, in context, if you were to take everything that we do in jiu-jitsu, Leo Viera Backtake included, this isn't even on your radar for things to worry about. But the things that really should be on your radar, we need to be a little bit more careful of.
Well, everybody watching that accident who had any experience goes, oh man, I've never seen like of all the moves that I would have expected somebody to get paralyzed from, this isn't one of them.
Hallelujah. This is exactly the actual reaction of the community.
Like, and I would imagine that it would happen from a flying armbar attack. Like, if I did a flying arm, if I saw a video of and I have seen people doing flying armbar attacks knock themselves out.
Of course.
And if it had gone a bit different, and the guy does a flying armbar attack and ends up breaking his neck or injuring his neck in the same way, I'd go, yeah, I could see that. But this one, like, I can see the mechanism by which it happened.
Or anybody would be able to see the mechanism. I didn't understand because I was reading Henner's description of it, which made no sense, saying he was pinned to the mat. No, he wasn't pinned to the mat with the arm traps. So I'm thinking crucifix with a roll. That's what I was thinking. Or Leo Viera Backtake, but the arm pin doesn't make any sense. And then I saw it and I was like, that arm isn't pinned. Get out of here with your arm pin nonsense. Yes, it's pinned. But he's defending hooks with the arm pinned. It's just clever. It's clever. Clever stuff. I'm going to maybe use that type of thing. That's novel. And the fact that it was novel really hurt him. And it really has no bearing on the safety profile of the technique, which is not all that safe. But it was not seen as egregious. We've already or not egregious. I need to stop using that word. It wasn't seen as like any sort of like dangerous move. It's standard of care, standard of practice within the jiu-jitsu community. So yes, that's what I need to do. Like I've been joking around with my students. I've been making like a caricature of myself going, no, you're not rolling. That's a liability everywhere I'm going with everybody. But yeah, I definitely with my kids the next day. All right, kids, we're doing the backwards roll. The backwards roll is for turning your neck whenever you're stacked on it. Break fall this and the all that stuff. I definitely feel ultimately I'm going to do very little differently. And part of this trial,
perhaps documenting basic break falling and documenting. I'm looking at it from a liability point of view, from the exposure to risk in the fire department, right? If somebody falls off a ladder at a fire call, the first thing they do is go back to the training records to see, did this person train ladders sometime in the last year?
and
if
this
they
is
didn't,
the argument that was made as far as curriculum. They got into asking Henner about curriculum and how it was normal to have a curriculum.
but maybe you could say
part of it.
we covered the basic safety maneuvers. Like